Happy Public Domain Day. On January 1st of every year is Public Domain Day, which means that any works of copyrighted works that were published or created as of, for this year it's 1930, I'm doing this in 2026, so we're looking at works that were created in 1930. They automatically become public domain on January 1st. So for this year, some of the notable properties that are now public domain include Betty Boop, the character, the first 4 Nancy Drew books, the Maltese Falcon, the book, not the movie, and a bunch of great Gershwin songs, including I've Got a Crush on You, But Not for Me, and Dream a Little Dream, which I'm not sure is Gershwin, but it was done in 1930. So what does this mean? So what does it mean to say these things are public domain? What it means ultimately is that anyone can use those properties, those songs, those characters, those books, and do adaptations or do illustrations, create new art, or just, slap them on t-shirts and sell them without having to pay anyone else or without having to get their okay. And so up until a couple of years ago, if you wanted, for example, to do anything with Betty Boop, you would have had to go through whoever was managing the property, which ultimately it's the estate, because after the author dies, there's 70 years where the estate can benefit from the property. So, and by the way, the laws have changed in terms of copyright term over the years, so I'm not going to get into the complexities of that. Just know that if it was created before 1930, it's public domain. And that's in the United States, of course. So one of the ways that public domain matters is, again, when it's not public domain and you want to do an adaptation of like a Nancy Drew TV series or another Nancy Drew book or a Betty Boop series of cartoons or whatever you want to do, you need to get permission from the copyright owner. If once the works become public domain, you don't need to get permission from anybody. You can do anything you want with it. So I understand there's a Betty Boop horror movie that's in the works right now. That'll be interesting. And that's how you see sometimes these sort of darker takes on some of the popular characters. If they're public domain, there's really no one to stop them. So that also means, of course, you don't have to pay. So if you don't have to pay a license fee or a royalty to use those public domain works, because they're literally in the public domain. They're just free to use by anybody. So one way to look at this is, and a lesson you can draw is, here we are in 2026. If you are creating content, or if you have a business and you're developing goodwill, or you have some innovative products that you're doing, and you're not taking any action to protect those works that have value that you are creating, then you can think of it as you are essentially allowing them to be public domain. So on the patent side, that literally is the case. Until a patent is granted by a government, whatever you're creating is public domain. So if someone reverse engineers it, that's fair game. And this is a really hard pill to swallow. Just, take this lesson to say, if you have created something or are creating something that you think has a lot of value, have a conversation with someone about getting a patent filed. You don't have an infinite amount of time to do that. There's a short window. So, don't delay. When it comes to copyrights, technically the copyright exists even if it's not registered. But as a practical matter in the United States, you can't file a lawsuit to enforce a copyright unless it's registered, and you will be giving up some of the most powerful leverage that you have in a copyright enforcement action if you don't get it registered pretty quickly. There's a good chance that you're not going to have statutory damages, and that can be make or break when it comes to actually settling and getting them to stop versus having protracted lawsuit that's going to cost you a bunch of money. So effectively, if you haven't registered your copyrights, you should think of them as being basically they're just in the public domain because it's going to be difficult for you to enforce them. So please register your copyrights and do it promptly. And then as it comes to trademarks, it's a little bit the same as copyrights in that you have trademark rights and they don't need to be registered to be enforced, but effectively, if you're serious about your brands and you want to prevent others from, free riding and abusing and just straight out stealing and copying your branding and confusing your customers, then you need to take action without delay to get those registered in the USPTO if at all possible, because that's going to be your best protection against allowing them to be treated as if they're public domain. All right, so I hope that was helpful. Happy Public Domain Day. Catherine Cavella, IP Works Law.